evening. Well, good afternoon. Or maybe good morning, wherever you are. Welcome, welcome. And I thought that we should do a little dive into Courtney Clenney. The lovely, well, she's not a circus artist, but she should be having a knife throwing show because she has the accuracy of a young Storm Shadow, if any of you know G.I. Joe. Because it was purely self-defense that she threw a knife and it's embedded 6 inches into her boyfriend's chest, as we all know. Yeah, I'm sorry. I thought they would be done, so I said it. It's because I have Molly. I also would have postponed it another hour, but I have little Molly, so I'm sorry for. I know if you want to go watch Closing, go hang out with Daddy too. And I'll bet you'll need your blood pressure medicine if you're going to listen to that prosecutor, because they are going to pull out all the stops in this case. Hey, Texas Jen, how are you? Well, thank you for stopping by. Amy in Boston is here as well, and Miss Irish. Iris and I was looking at Mexican restaurants in Knoxville yesterday, and she wanted me to visit the Lazy Donkey. That's a bit harsh calling a donkey lazy. But no, let's get straight into it so you can go back and be on verdict watch. It did, yeah, but the problem is when I read it, I don't know what a chimichanga is. I never had a chimichanga. I thought a tortilla was a big corn pancake wrapped around stuff, but it's only the corn pancake. Then it's called something else when you wrap it. American food is weird. Talking about being weird.
Hi, I have a few
Hey,
minutes, so
Jennifer,
I thought I'd come to say hey.
say hey to Peter A. That rhymes.
Hi, Peter A.
Yeah. So they're starting closing over at Daddy too.
Yeah, they're going over some stuff.
Yeah, so it's gonna be. I'm telling people, remember your blood pressure medicine when you have to listen to that DA.
Hmm.
All Mexican food is the same stuff, just arranged differently. Well, I'll try it. It. I'm not sure. I had Taco Bell before, so the bar is pretty high. Yo quiero Taco Bell.
Oh my God.
I think that means I like Taco Bell or something like that.
Is that what it means?
Yeah, that's what it means.
Okay.
Well, that would be the first time you got mad at me. C Star, welcome. No, let's look into what happened in the funny world of OnlyFans model Courtney Clenney. Her parents were arrested in Texas, I believe it was. The parents of Miami OnlyFans model Courtney Clenney has been arrested in Austin, Texas. Kim and Deborah, 60 and 57, are the father and mother of the 27-year-old adult model accused of strangulating her boyfriend to death in their luxury apartment in April 2022. Um, Sources tell Fox that the search warrant conducted in Texas led to the arrest. Additional details are not immediately clear. So that's not much we know. I tried to find it yesterday, but I couldn't find the warrant to see what exactly they are talking about. This is the lovely lady from her trip to Aspen. If you've been following my channel and watched the Courtney Clenney stuff, uh, I might draw your attention to this part right here, this part right here, this part right here, this part right here, not the boobulets, but the discoloration, and this part right here, and maybe this part down here, but it could be just leaning on a table. To me, that looks like someone has grabbed her multiple times to try and stop her, because we saw in Aspen that she went absolutely ape sheep uh, on
Sheep.
Christian, because he forced her out of sobriety because he talked to another woman. She had been clean
Mhm.
for 2 weeks, 2 weeks, and he ruined it. So, and to people saying, well, it's clearly marks of abuse. One of the things I notice, there's no marks up here. To me, it looks like grab marks more than
Yeah. And if you've
more
seen
than
her swinging on her boyfriend,
yeah.
you you would know.
I wish I can send you a Chihuahua saying that it used to be a Taco Bell mascot. I have a I have a friend who has a Chihuahua. It's a weird little animal. I'm not sure they know their dogs. I think they're rats. Hey, HT, how are you doing? Yeah, it looks like bruising. And this is for her OnlyFans. This is how she chooses to. Again, she, as you can see in the thumbnail, she doesn't look like this anymore. When you're not on the Colombian diet and get all your fillers and all your filters, you kind
Mhm.
of hit the wall 200 miles an hour. Yeah, she is wearing makeup, and the picture is a little bit small on your screen, but right here it looks kind of like there's something, a blemish on her lip, but that could be a little gift from a former lover.
Oh God.
Yeah, it could be. It could be Smix. It was a little stuffed animal back in the day till they got rid of it. Yeah, I know you had that little Chihuahua dog saying, "Yo quiero Chaco Bell."
Oh, Iris is gonna slap you.
Well, that's why I don't go to Texas. Travis County said they assisted with executing an out-of-state warrant, but declined to comment on any specific sources, which first reported the arrest, told the outlet the warrants were related to a potential evidence tampering investigation and a laptop that Clenney's father allegedly took from their apartment after the police released the crime scene. Um, and the rest is just a summation that it was a self-defense case, and her lawyer said that they had no response to this. And previously told Fox Digital there was clear evidence of self-defense and that Obomsili had choked Clenney in the moments before the stabbing. We can't really see that in the pictures, but yeah, she had no choice but to meet force with force. In a 2022 video recorded during the trip to Aspen and made public earlier this month, Clenney shouted at and repeatedly struck Obomseli in front of a third person who recorded the encounter. She blamed Obomseli for her own drinking, telling him he was fired and screaming at him to leave. She also accused him of costing her money and flirting with other women. Less than 2 months later, she allegedly stabulated him to death. Seeing this picture, it's hard. I know you ladies can do tricks with makeup, but it's hard to
Mhm.
see it's the same person. But allegedly, what have happened was um, the laptop is supposed to be Christian's laptop, and they are supposed to have hacked or tried to hack his password. That's what the rumor said yesterday.
Mhm.
Mm. So that's quite interesting, because that'll probably not be seen as a good thing. Looks like a bruise on her chin. I- Is it? Well, I'm I'm not sure, but it was more the if you especially you could see on her upper arm. It looks like as a guy who have had a relationship with a violent woman, this is normally where we grab them so we don't get slapped. Um, because if we punch you once, you'll feel it. Hey, Kim Farrell. Farron. Yeah, well, she stabbed him. Well, it was probably self-defense back then too. And when she knocked him over, no, when she threw stuff at him in Las Vegas, when she hit him in the elevator, it was all because of nothing. This is so bizarre. Are we now gonna charge all relative for the crime? No, um, but allegedly they had taken Christian's computer from the crime scene after it was released from the police and tried to break the password on it to maybe get rid of evidence. That's the charges as reported. So it's not that they are charged with the the stabbing. It's that they apparently took his computer to try to get into it. So so that's it's not related to the stabbing per se. It's trying to cover evidence afterward. But yeah, yeah, it's absolutely not connected in any way to the stabbing per se. It's the evidence according to the related to the stabbing. So it's
Mm.
not like the Crumply case where they should have known that. And again, she's 27. So I'm not sure they knew she was going to do that. But her dad was a business manager, and I believe he edited some of her videos.
Ugh,
Yeah, that's weird.
yeah.
If my daughters called me and said, "Dad, I got this business idea," there would be a monastery who had two new nuns that day.
Hmm.
I would do no editing, and not just because I'm very bad at editing. No, not absolutely nothing like the Crumblies. It's all about tampering with evidence. But yesterday, yeah, well, not like the guy in the stepdad in Australia who spent, was it like $2,000 on his stepdaughter's OnlyFans. He was the only one paying for it. That's weird.
What?
Yeah,
All right.
they asked her for password and got it, but gave it to lawyer because it only had a coin exchange or something. Yeah, we don't. Apparently, there's some video out there with them saying we got it or we got in something, but I haven't found that yet, and I haven't seen the charging documents. Yeah, he was a business manager, so he. But there was rumors he had edited some videos too. But they had a court meeting yesterday because the state wants more information from the defense, and both the state and the defense wants the other side to quash certain elements that had been leaked to the press. So I thought we should watch that as well.
Yes, good morning, Judge Frank Davis on behalf of Ms. Clenney.
Supreme Publicity and Diane Krems on behalf of Ms. Clenney.
Hi, good morning, Your Honor. Tara Kalas, appearing on the case this morning. I'll be guiding the notice of appearance date this afternoon. Good morning.
She lost weight.
This morning, I'll be guiding the notice of appearance date this afternoon. Good morning.
She's not as pudgy as she was last time she was in court,
Well,
but she's
probably
very
gotten
pale,
into a good routine now since she's been there so long.
and she got her hair fixed as well.
She's got the jailhouse scrunchy do, the little curly hair.
Yeah.
All right, so we have two matters in front of us today, essentially two matters. One involves a motion to compel discovery, and the other involves a petition for order to show cause, as well as several replies back and forth.
And Your Honor, just for some housekeeping issues, if Your Honor wouldn't mind,
Sure.
at this time, in case F22-14137, the state is filing an amended information. The defendant is still charged with second-degree murder with a weapon. We're adding another count of interception of wire, oral, or electronic communications, a third degree.
Yeah, they got her with a third-degree felony now because of tampering with wire or electronic communication. So that's related to the laptop. Hey, Stace, how are you doing?
Felony.
Stace.
We want to arraign her on be a new amendment.
Can we see it? We've never.
We've
heard
never
of
been
this.
notified of it. We've never seen it, which seems to be typical these days.
All right, no, we're not going to have any of that here. If we're going to do any.
I like this, Judge.
Your comments or grandstanding, we're going to hold off on the hearing today.
Your Honor, while they look at that also, the state is also filing discovery for the court and handing over to defense a copy of the filing, as well as it's the warrants, Judge, that created the new case.
All right, Mr. Prieto, you did hear me just now, right?
Yeah, I did, Judge.
Okay, so we're gonna keep it purely professional, and that includes everybody in the courtroom. So if it's not kept professional, then we're going to shut the hearing down today, and we will do it on another day when it can be professional, okay?
Understood, Judge.
Thank you. So no throwaway comments. Right,
With
you are
that,
in.
Judge, on behalf of Ms. Clenney, we're enter a plea not guilty, demand discovery, and request trial by jury.
Thank you.
Your Honor, with that being said, we do have an information for the new case. We can address it at the very end, or we can do it right now. It's up to you, Your Honor.
You can go ahead and address it right now.
So
Let me get that.
in case F242015, the state is filing a consolidated information, consolidating F242016, F242169. It is making defendant A, Kim Dwayne Clenney, defendant B, Deborah Clenney, defendant C, Courtney Clenney. We're charging one count of offenses against computer users, third-degree felony for all three defendants. We have provided a copy to defense.
On behalf of Ms. Courtney Clenney, we have not guilty demand discovery and after the case we set trial.
And then for,
She's looking
Mr.
better.
Clenney and Mr. Kim Clenney, who's representing them?
Your Honor, Kim Clenney and Deborah Clenney were arrested day before yesterday in Austin, Texas. They were subsequently released. They will be appearing in Miami at some point to self-surrender at TGK. There's a $5,000 bond, so those bonds will be paid and they should be released, is the messages I'm receiving. But as of yet, we do not have counsel for them. Due to the nature and circumstances of what the state's allegations are, I don't think that myself or Ms. Puglisi can represent them. So we will get them counsel.
Does Your Honor want to set an arraignment date so
Well, I
that?
think that we need to set it for them to have attorneys and for us to make sure that they are represented. So I'm going to go ahead and set this as I would another case and set it for 2 weeks for court attorney for them to come in with counsel. They don't have to be here as long as the counsel is filed a notice of appearance, that's fine. We'll do it the same as we would any other case. So 2 weeks for F24.
2015 A, B, and C.
A, B, and C.
Yeah.
216 for court attorney.
And you want the C to travel along with them, Judge, even though it was arraigned?
An arraignment will be scheduled that same day.
All right, so then let's go back to Ms. Clenney's case. For the motion, we're going to start with the motion to compel discovery, because I think that that's going to be,
Yeah, I love how they turned up the sound, but you only get the background noise. You don't get the mics because they don't really use the mics. I'll try to take the booster. Oh, sorry. I'll try to take the booster off because it might be that humming goes away.
and then anything that would be to the experts, as specifically that you're requesting.
I was using an example.
Oh, no, must.
Right, so this is the state's motion to compel reciprocal discovery based on some things that have been turned over, some things that have not been turned over. So let's discuss what you are seeking at this point.
Judge, the rules of discovery are clear that the defendants have a obligation to, just like the state does, to affirmatively provide discovery within 15 days. There are, among those witness lists, reports, statements that are made by those listed witnesses. Some discovery since the state's initial filing in December has been provided. We received a video that we were requesting for over 30 days. That video was removed, had audio removed. There's clear communications in the video. Those are statements of those people. We are entitled to that. The defense, for example, yesterday amended discovery listing witnesses. That's perfectly fine. I provided the court a copy via email. So again, they just have to provide a list 15 days upon
What's wrong with his
these
alfalfa here?
witnesses becoming witnesses, assuming. So that also is contingent with
What'd you say?
statements, contracts, agreements.
His hair back there looks
it's
weird.
anything that would be in theory
His
discoverable.
hair?
So for example, if they retained an expert, a point of contention might be this person's retainer.
That's not-
You pay someone $1 million.
Oh, yeah,
they might
it's
do whatever they want.
definitely weird.
Say they haven't received any retainer agreement.
I want to see the front of it.
0 throwaway comments. Okay, I understand what
Sorry,
you're
I'm sorry.
asking about discovery as far as.
I like she don't want all of this.
I was
grandstanding.
using an example, Judge, of a hyperbolic figure. My point is, and then that wasn't meant as a throwaway comment, it is a question of credibility, what a witness might be
Congratulations.
paid, and the state is entitled to that discovery.
Him, one
To
like-
date, we have not
one,
received that.
Okay, I'm sticking in a poke.
Similarly to the witnesses that were listed yesterday, the state did not receive any statements that might or might not have been made by these persons. Additionally, and pertinent to the collateral case is,
It's
Mr.
weird.
Clenney was listed by both the state and the defense, and the communications in writing by Mr. Clenney with the defendant's counsel are all discovery needed to provide. So notwithstanding the fact that the state received some of those communications via a warrant to Ms. Deborah Clenney, those communications, all of them, are discovery to the state.
Is that in your motion to compel?
No, Judge, the point is that some of this became sensitive investigative issues once it was discovered by the state in December. So some of the matters I just could not approach because frankly, I referred it to my new police because I'm not.
I love having Molly here, but he's
And
turning up my
I'm not an
camera.
investigator, I'm just a prosecutor. So some of these matters I just could not disclose or pursue because then it would hinder that investigation. So, but it's just a basic obligation under the rules. There's no obligation for a defense attorney to invoke discovery. If they do, then they have to comply with it.
Right, so what is it that you believe that is outstanding, that you are specifically asking for this time? I know that there were, it looks like the videos pertain to potential expert witnesses that I think at least 1 or 2 of whom have been listed. Yes, at some point the state is entitled to discovery regarding those expert witnesses that they've, drafted reports. They are entitled to retainer agreement, but what is it that you believe at this point specifically that you are requesting that is in your motion to compel?
Yes, Judge. The state is requesting the names and addresses of all witnesses that the defendant has, quote, uncovered, because that's the words used by counsel. I'm not making a throwaway. That were present for any of these recordings, a list of the individuals that were present for the recordings that were made and provided. Specifically, there's several set of videos, but the studio video, for lack of a better term, one where there were 5 different takes, and there was a secondary video that looked to be outside. I don't know if that was only the defense's expert or other persons there recording it. Those people are pertinent for the any discovery. The audio of the videos that were already provided.
It's kind of stupid to
Anyone
keep
that
the
was
videos
involved in
without the
editing
audio
of
in
those
it.
recordings as
Yeah.
well. Particularly some videos were in slow motion. I don't know if that was a subsequent edit or anything else. That's obviously pertinent discovery. And then actually in the last line of our reply, I put statements and reports of any of the witnesses by the defense that exist in their care, custody, and control. That, and the state would just piggyback since they amended the discovery yesterday with some witnesses, whoever those witnesses are, if there are statements of those people.
I can't tell whether the witnesses that were listed yesterday were experts. I'm not sure who they were, but you guys can respond to this prosecution.
Sure. First of all, Judge, under 3.220, the defense has no obligation to disclose witnesses unless we intend to call it. It's that simple. The witnesses that we listed recently, we intend to call.
The experts as well.
The 2 experts that we listed, I think a couple weeks ago, yesterday I amended with 4 civilian witnesses. I believe it's 4
These
in
are
total.
all-
Those are civilian witnesses, one of which, Arthur Cupp, we identified through body worn camera that the state provided to us, so that person was readily available to them as well. He gave a statement to police, so his statements are contained therein. Any interviews that we've conducted of these witnesses, we will get those statements over to the state prior to them deposing them, so that they can be well prepared to do so. As far as the audio of any video, I was present for the filming of our reenactment. There was no audio taken. I will double check with the film crew. I don't see how.
You didn't record audio in a reenactment.
That's weird.
Yeah, because using this or using a camera, you would have to turn off the audio. Wouldn't you normally just have the audio running? That seems weird. So yeah, you can't hear me well. I was sneezing before. Sorry. Yeah, they apparently made a reenactment of the. Well, it's going to be interesting because, according to her, she threw the knife at, was it like 5 feet, 3 or 5 feet distance, and embedded it in the tattoo of her name on his chest. So it went in like 6 inches. That's a pretty good throw. I'd like to see that reenactment because, as I stated before, you have to be a very skilled knife thrower to make that throw, because it's actually like the rib cage is kind of put in there to protect your internal organs. You have to hit it really well. Yeah, that's quite the aim, especially the tattoo with her name on it. That's the irony in this case. But it's going to be interesting. And 2 experts, I'll bet one of them will be a spousal abuse expert. Maybe that's why Sarah Boone can't get one.
A cameraman is going to be listed as a witness. I guess I can list him as a C witness that shouldn't be deposed. I mean, these are ministerial acts by these witnesses, but I will get a list of the film crew that was there. I'm going to provide that to the state.
All right. And then editing, any reports that are being generated by your experts? I don't know whether they've been generated yet, but.
No, there are no reports, Judge. And as far as the editing, that will be, I don't even know who did that, but I'm guessing it's the producer that we contracted with, which is Coal Power Filmworks.
That's going to be discoverable.
Sure.
Okay,
Yeah,
I gotta
we'll
hop off.
list him.
Yeah, have a fun meeting. See you later, honey bunny.
Anything that would be
Bye.
discoverable with
Bye.
your experts, you're going to have to turn over, which involves, their CV.
Yeah, knives are readily available in every household.
They were using to rely on when formulating their opinions.
Yeah, the 2 experts that we've listed to date, Judge, we have provided a CV for our medical examiner, and also every single case that he's testified for, we've provided that already. There are no reports, so there's nothing left to disclose on that particular expert. Our knife throwing expert didn't have a CV. I know he worked on it. But we did give the state a biography page that's on his website. That was the best we could do. So we can't provide something that doesn't exist.
Throwing
But as soon as
expert.
it's all put together, we will do that in due time.
And I wasn't going to cover this case. Now I think I have to.
All right, so, and again, I'm just going back up
Knife
to
throwing
this
expert.
portion that the state brought up first, which is the names and addresses of all witnesses that have been discovered. And I think that was taken from maybe some sort of media clip or from just your words. Are the new witnesses that are on the defendant's witness list some of those witnesses? Is there anybody else that you intend to call that you have referenced that you have not provided?
No, not at this time.
All right, then at this point.
Yeah, it sounds like a cool guy. And he doesn't have a CV. He only has a web page.
The one thing I will mention is.
At a circus?
Mr. Quinn did make reference to communications with Mr. Clenney, Kim Clenney.
Yeah, that wasn't in his motion to compel, that was just made.
Could be in a Renaissance Day, yeah.
That that's going to be a more touchy subject because of an nature of, what communications are privileged and what aren't. So I'm going to ask you to put that in a separate motion, and we're going to address that, especially given the fact that he's now charged, I think, separately.
Yes,
That's a safest thing to do that there.
Your Honor, just two matters before we move on from that. The two witnesses listed yesterday have to be determined addresses in Canada, and then we have international issues in terms of setting them in service. That we'll cross that bridge, but I'm just.
I mean, at some point in time, you're going to have to make them available for deposition. I'm sure that they know that. And yeah, you can't, obviously, you can't.
No, they're saying self-defense. He
And
was
also
choking
just
her.
So,
She was choking him, her, and she had to react. And then I believe I think there's an interrogation. She says he's coming at her again. At 3 or 5 feet, she takes a kitchen knife and throws it, and hits him directly in the heart with the knife. That's why I say this is gonna be a great throw. Hey, Sassy Pants, how you doing? Yeah, she had what was it? She had like 3 million in the bank with 4 lawyers present right now. She doesn't have that, and with her parents, with 2 times $5,000 bonds, it'll gonna drain fast.
the court knows is that these were individuals that were also interviewed by the police on the night of the incident. So the state is aware of them and has their recorded statements already.
But their addresses aren't listed in the warning.
Correct. Judge, I can clarify that for the court. Our investigator attempted to speak with them again, and they had subsequently changed their phone numbers. But we do know that they reside in Canada, but at this point, I don't have their address. I don't have a contact number, but
Well, it's better than
Happen
into the
again.
Colombian
They-
pockets.
The state has their statements that they make to the police, and I believe they're actually, I don't know if they're actually listed by the state already. They should have been, but so they're state witnesses as well.
Judge, I'm sorry.
No, I think the focus
Second
on
matter. The second matter
TV against
is,
men and the
when
violent
witnesses are listed
nature
by
of
the
it is
defense,
becoming more and more
there's no
obvious because
category
men are starting to talk
applications
about
of
it.
defense. Only category applications apply to the state. The state has an absolute right to depose all witnesses.
That's fine.
I made a short
That's
about it this
where
morning.
Our issue becomes is they might have been listed by us because we have an obligation to list all persons we know to have.
I haven't heard they're going for the
If we
death
list them,
penalty.
It triggers our right to depose them, and that is the equation here. And I do want to highlight one more issue before we move on to compelling, is that it's always on the eve of a motion before this court and a hearing in this court when we receive reciprocal discovery. That is a problem because the rule triggers 15 days. I absolutely appreciate that the 15-day period is when the defense decides that they're going to do that at trial. But that exception, that definition would swallow the entire rule if we decided yesterday, we decided this morning. And so I just want to make sure that everyone's aware about that. Is you can't just have.
I'm gonna have to take them at their good faith statement that they are finding this in a timely way as soon as within 15 days of the consider that they're going to list. the
Well, this
address.
is just a hearing about
Okay.
a few motions, but the case
And
is
hopefully not.
very interesting.
Okay, so that I think takes care of our motion to compel. It sounds like you guys everybody's in agreement as to what needs to be turned over. As to Mr. Clenney's statements, that's gonna be separate.
Judge, and I ask for a final ruling that it's granted.
Yeah, it's granted. And I don't know that there was, let's see if there was is there a proposed order attached to it? If not.
No, Judge, because I figured it would be.
It is in Men in Black
More.
3, I believe.
So, I'm working with what's said publicly, so.
Judge, we'll draft one, we'll get it.
Okay, draft it to me.
I actually thought that the JD case was great for us men because finally it was proven that women can be the aggressive partner as well,
Second motion.
even though a lot of people don't believe she did anything at all. And I like the court reporter's polo shirt. We men should not be afraid to
Let's
say
go
other guys
to-
have a nice shirt.
The second motion for which I received another response to yesterday. I guess it states reply and response. in support of its own petition. So let's go to the original petition and we will start addressing the issues here. Really quickly before we go on to that, we're not addressing, I know that the last time that we were up, we had the motion to suppress and the defense had withdrawn the motion that they had filed. Was there ever an amended motion that was filed on that or not?
Not as if yet, Judge. What was the last?
Well,
So then let's go back
yeah,
to what was-
because women do no wrong. You know that,
I've
Irish.
read
It's always us men.
the reply in support of that you wrote yesterday. I've obviously read the ones that have been previously filed. I know that a lot has happened within the time between the original filing of the petition for order to show cause and today. So let's just get started. Go ahead.
Yes, Your Honor. The state filed the petition to show cause on November 3rd. We emailed it to counsel. We did not calendar the matter as a matter of professional courtesy to the respondent. There's, in trial, of course, the trial where previously, there's the expression about ringing the bell. And once the bell is wrong, it can't be unwrong. The state has, on purpose, because of the attention created by this case, specifically by the respondent and his client, not sought to limit public speech by anyone.
I think she looks way better now than
when
she has
the
done
statement
before.
counsel filed
It looks
a
like
motion
she's
for
getting
reduction
over her
and
drug
record.
habit.
And
Talking
the
about drug
premise of that
habit.
was essentially so
Hey,
that
Lefty.
the micromanage discovery and would supersede chapter 119. That's not settled. Judge Clenney at the time rightfully denied that motion. The premise of it and counsel's issue was that the elected state attorney at a press conference, she announced the charges. She stated the arrest warrant facts and provided one of the examples in the arrest warrant. As the court would know, the state does not telegraph its case on an arrest warrant that requires mere probable cause. And we did not. That was on purpose. The state is thrust into a position, particularly by the defense counsel, to maintain this case's interest in the public, to inform the public that there was actions at stake. And I juxtapose that against the last 48 hours where the state has not made any public comment and has not made any public comment since. The defendant and the respondent have chosen to telegraph their case in public. That is their prerogative and frankly formed a lot of the basis for the state's motion to compel. Absent statements made by the counsels, the state would not have a basis to move to compel discovery because we wouldn't have known. So to that effect, the state has deliberately sought not to raise this issue. One, as a matter of professional courtesy. Secondarily, because there is a great public attention and interest in this case. And thirdly, and I say this with complete candor, it is benefiting the state. A defendant telegraphing their case benefits our strategy and benefits state litigation. So we sought no interest in limiting the defense counsel from telegraphing their case. I think a common
Get
expression
to
used
the
here
point.
is the defendant had a right to remain silent, but was unable to. And we were perfectly okay with that. The defendant's attorney walked a very fine line several times, as we outlined. There was this court's hearing on the Arthur hearing, we made inappropriate remarks, the state rejected, of course, his thing. Then several interviews, remarks the state would not have, suggested making a finding. The defendant, the respondent walked up to the line when he called the victim, who's deceased, is unable to defend himself. And there's a particular history that comes with humanizing people, and the big elephant in the room is the racial disparity. That cannot be ignored, but the state nonetheless restrained itself.
What? So now it's a racial matter because he's a black guy and he called him an animal. It was because he was black he called him an animal. It's not because he was a violent animal. Is it just me who thinks that's a little bit she dated him for a long time. There's no trying to imply there's a racial motive in this one. We never heard her use the N-word, I believe, in any of the videos. And she was really angry in those. Don't do anything, make everything into a race question. I always now feel like they're going to say it's all over YouTube now. It will be mentioned later. It's quite a stretch to do that. I don't like that. I'm sorry. I hate when they make it to a race thing, because saying that he dehumanized him and he was a black guy, you dehumanize him to make it about his color. He was a human being, no matter if he was black, brown, yellow, pink, polka dot, whatever. He's a human being who's not there anymore, but you want to turn it into he was a color person. I hate it. I hate modern woke crap.
That crossed the line, the respondent crossed the line when he gratuitously, and I don't know if the court has reviewed the video, but it's been available for the court.
Yeah, and it's just dehumanizing as
Not prompted
as
for no other reason.
the other
Just
side
volunteered that the
would be.
victim was sexually battered by a family member.
I like Dr. King. He had the
That's
right
not
one.
appropriate. That achieves.
Yeah, she was just a
no
crazy B word.
It is not
He
asserting
was an idiot for not
his client.
beating her.
It is not saying the evidence will show that his client is not guilty. It is not saying when the case will be heard next. It's not discussing what preliminary or procedural matters might come up. That was, for lack of a better term, a cheap shot. That was wrong. And that crossed the line. The state is then left with the remedies, or the following options. Do nothing and embolden the behavior that has been progressing and escalating. File a petition to show cause, not calendar it. Contact counsel and say, please stop. File a petition to show cause and calendar it. Or move for a protective order and a restraining
We've
order
seen this
against
guy in a
counsels
trial before.
and the litigants from making public comment. The state took its least restrictive means. And again, out of professional courtesy, filed a petition because it needs to be a matter of record, sent it to counsel, emailed counsel saying we're not calendaring the matter. We hope the conduct in the petition ceases.
I think he
3
was
months later,
starstruck by
The
her,
respondent
and
chose to reply and bring up the matter with the court.
she was
The
just
state
crazy.
Candidly has not sought a remedy on this matter. Frankly,
Very
as far as
crazy.
the state was concerned, because there was also no reply to the state's communication.
Maybe because it looks a little like
that
Legal
was
Eagle.
bridge. And we're here litigating this matter because the respondent chose to. To skip ahead regarding our reply, since the state's petition to show cause, and the state has not amended its petition to show cause or filed a subsequent petition to show cause, the respondent has arguably engaged in further conduct that is further escalating and raising the temperature. That requires this court's attention. Again, we discovered this knife throwing not from court pleadings, this knife throwing expert, but from counsels on TV. We discovered that there would be a reenactment video, not from counsels, and there was email communications by the state with counsels during that time regarding discovery, but from the respondent's co-counsel the day before Thanksgiving going on TV. That is not a way to litigate this case. We then spent, and I outlined in the motion to compel, almost 30 days berating the defense via email to provide us discovery because we did not want to delay the proceedings. We want to review whatever the materials are, decide our strategy, conduct our discovery, and litigate the case. It's been 17 months roughly since the defendant's been arrested. April 3rd, 2024 will be 2 years since Christian was killed. And it feels as this case is moving at a snail's pace. So to put it bluntly, we want to get down to brass tacks, and litigating these collateral matters are not in the state's interest. And it's especially the state has not sought to address this matter. So the respondent wishing to take up this court's time with that matter rather than getting to the discovery. And frankly, the statements that have been made in the last 48 hours are just increasing that temperature. And if counsel wishes to litigate and get an order from this court, the state welcomes it. We will comply perfectly with an order if this court were to craft one with the Polito. We provided the court a draft of that order that was affirmed on appeal. The state has no public statements to make about this case. We want to try it. We want to try the defendant and the co-defendants as expeditiously as possible.
In your response, you also mentioned, and I also happen to see the fact that, and I don't know whether you want to address it, but I'd like, if you're going to, for you to go ahead and do it now, the fact that there is some sort of docuseries or TV show in the making prior to the trial in this case, where the officers and the witnesses are allegedly,
He looks
interviews are
like a
being
football
stopped
player.
from everybody. I had also seen it online.
Yes.
And was very surprised to see that.
I can address that. So the state has not ever been approached regarding from TMZ regarding our comments and participation in this docuseries. We learned about it almost contemporaneously with one another. We served a subpoena on the defendant's management company for behind the scenes information, contract, et cetera, premised off of the respondent's statement that she was allegedly human trafficked. So we expect that might come up at trial, so we might have to rebut that.
So she was human trafficked. What? She's an only. I don't know much, but it's funny when the shit hits the spinning thing in the ceiling. They're always Amaranth. Her husband made her do it. She didn't stop as she said she would. She went away for a little time, maybe to have a little nip and tuck. Who knows? I don't know. It's just stuff I make up. Her husband forced her to it. Now this lady is human trafficked. There was the other one who blew up like last year, who been in smexy music videos and throwing herself all over the place. She was also human trafficked. It's kind of the new "I was great" excuse for everything. I bet the $3 million she had on her account didn't feel like human trafficking. But is that now a part of it? And why is TMZ doing a documentary in some form of connection with the defense? It's to me, it's just weird that why don't you focus on getting out of prison instead of then you can make your document soap afterwards. The difference between before and after prison. Well, she's looking better now than in my thumbnail.
The counsel for that company informed us that they were approached by TMZ regarding a docuseries that they wanted to interview his client. At roughly the same time, and the court has the emails in our exhibits, the city of Miami's public information officer received a request from TMZ to interview the lead detective by a person named Brian Andrews, who's a former local newscaster and the president of the PR company. We didn't want to go up, and it was Christmas, and New Year's, so Mr. Adolph emailed the respondent and his counsel requesting this, whether they were participating in this because it's appropriate. And 30 hours or so later, we get a response, essentially neither accepting or denying anything. And about 10 days later, we find out from Lexington Capital that on that date, the respondent sat with the defendant's co-defendants for interviews. And there's actually a few matters that came to my attention after the state's reply yesterday. TMZ aired parts of those interviews already as a apparent teaser. So, the damage has been done. There's nothing for the state or the court could have done, but it further reflects and impacts the perspectives and nature of this litigation. And the state wanted to take another step on this too, because again, it was brought to my attention yesterday, in part because the reply was being drafted and matters had been developing. TMZ, I believe, was the first to report the arrest of Mr. and Mrs. Clenney. And that reporting stated that they were arrested for tampering with evidence. Clearly, the arrest warrant doesn't state that. Clearly, the facts in the arrest warrant don't state that. Clearly, the state's information that was filed and sealed at the time didn't state that. That was not a correct report. And the state has concerns about the communication based on an inference of whatever was told to the claims on scene, because they weren't told of their charges because they refused to speak to the officers. So, given the intimate personal relationship the respondent's been having with TMZ regarding this docuseries, the state has obvious concerns that there's essentially going to be something televised, and particularly the state's concern, because it was alleged by the emails, is that this is being telegraphed from a particular perspective, and the state does not get to air an infomercial of the defendant's guilt before trial, so the defendant should not be either, and that is inappropriate conduct that the court should be alert to.
Judge, I object to Mr. Hanfield addressing the court for this particular motion. He's a victim advocate under Marcy's law. They have no standing to address the court for this particular motion.
So, yeah, Mr. Hanfield, right now I want to hear from the defense. You were the one who calendared this, to bring it to, I guess, my attention. It hadn't been brought to my attention before. But given
Yeah,
everything that.
It's always around,
particularly
stop at 6.5 on both scales.
possibility of a docuseries prior to trial, I think that we should be addressing it. So, for whatever reason you brought it to my attention, the state hadn't brought it to my attention, it hadn't been documented, you documented it. So let's discuss it. What is it that you believe, is appropriate about what you have been doing with the media, and why is it that you believe that you should be allowed to continue to do that?
Sure, Judge. And first of all, I'd like to say that I'm not sure a petition for order to show cause is the proper avenue. I think a motion seeking some type of protective order is more appropriate, but procedurally, if the court can address it however it would like.
It's the first time that it's ever been in front of me, on any sort of petition on any of my cases, to address this issue. So I'm not sure what the appropriate avenue is, but we're here, to see whether or not there needs to be a court response or anything.
Correct. And Judge, I brought this to the court's attention by countering it because this was already filed. It was filed by the state. And what happens once it's filed, based upon the media attention that this case is receiving, the media, either through public records requests or now finally the clerk has finally got us like electronic access to the documents that are filed, it's open to the public. And in that particular petition, quite honestly, there's comments in there that besmirch my reputation. And I'm not going to sit by idly while I'm attacked by the state. And with regards to inappropriate comments that I made at the Arthur hearing to the lead detective, I'm going to rely on my written response. I'm not going to dignify it with a reply verbally.
And I don't think that that's the bigger issue here at this point, so.
Sure. And the state's saying that they had to barrage us with emails for 30 days. If Your Honor recalls, that's the time my father passed, and I'm sorry I didn't get it to them faster. But we're working this case. We've taken lots of depositions, but this particular petition filed by the state, I believe, needs to be addressed because we are constantly, from the defense side, being barraged by them from day one. And, the state's saying they can't unring the bell. Well, you can't put the toothpaste back in the tube either. And that is why at the onset of this case, I sought a protective order to limit the discovery being released under Chapter 119 because I knew this was going to happen. The state aligned themselves with the Miami Herald and fought me on that.
The picture
All I
where
wanted
she's
to have,
sitting
and Your Honor was not sitting
in her
court at the time,
pajamas,
but all I was seeking
covered in.
was an ability for the
Show that
court
in
to
court.
review discovery
She'll
prior
choose.
to it being released under Chapter 119, not a complete gag order at all, because the writing was on the wall. My office probably received 15 calls as soon as the arrest was made. I wanted to limit this, and now the state can't have it both ways. It's the pot calling the kettle. They know under Chapter 119, when they fought the initial disclosure of discovery, that this was going to be a
It's easy to
subject
find
of
out there.
great
It's
media
in the
attention.
TMC
They
article
were happy
on
to
the
list all the items in discovery in detail, and then began the onslaught of Chapter 119 requests made upon the state to get all the video. To take it back, when Ms. Clenney was arrested,
Onslaught from defense or onslaught from media?
media.
Yeah.
A very
You,
carefully crafted press
lot of,
conference.
I don't think there's
This
pictures
one
of
was in
him,
office,
but
I
you
think,
can see
over
the
30
crime
years.
scene.
My
There's
boss,
a
she
lot of
was, I
blood
think,
in
your
there.
boss at some
He's
point.
totally
They're a very
covered.
sophisticated state of transit agency. I think the second or third largest in the country.
Well,
They have a public information
well,
officer.
throwing
They
the knife.
knew when that
It's
discovery was
good.
released that they were going to receive tons of requests for the videos, the audios, which are subject to suppression, but that's a motion for another day. But they knew it was going to be released, and they know that every time a media agency makes a Chapter 119, they're going to throw their hands up and say, well, we have to comply with the Sunshine State laws under Chapter 119. We're not giving it to the media. But they knew that from the beginning that would happen, and now they're hiding behind that to say it's the defense that is putting all these things out there. They let the toothpaste out of the tube, and we're trying to put the cap on it. Why? For example, the video released at the press conference of Ms. Rundle standing there going like this, we take issue with that. We don't think the facts support that. The elevator video was released because why? It's great for the state. The media is going to love it, but they don't supply it with context, which is the danger that the state was facing by listing all the discovery and media outlets picking pieces of, oh, send me this video, send me that statement, send me this interview. Nobody wants to request a body-worn camera of the defense witness, Arthur Cupp, saying that she saw Owen beating Courtney. Nobody advertises that. No media outlets are covering that for the defense. The state's not putting that out there either. As an obligation to defend my client, the rules allow for me to give pushback, to characterize the evidence, to make sure that my client gets a just and fair trial. We're not trying to impede justice. We're trying to make sure justice is done by showing when the media contacts us, hey, do you have a comment about the new video? It's not new. It's just they found it because the state released it. Or the Haddon Law Firm with Mr. Hanfield and counsel for the estate of Omonzelli release another video. And then the onslaught begins. Mr. Credo, Ms. Scalisi, do you have a comment about this new video? And in order to protect my client's right to a fair trial, I have to. I am ethically obligated to push back against the narrative that the state began to spin in August of 2022 when they had the press conference. Then again, when they fought the defense on a protective order, saying, no, we want all the discovery out there. Now they're complaining about the discovery that they released. The text messages that unfortunately show Mr. Omonzelli was a victim of a sexual battery are in the text messages they made public. This is evidence that was provided to us, it was provided to the media. And now they're complaining that it's being released and that I have to comment because things are being taken out of context. All the media coverage to date has been vilifying my client under narratives that we have an opinion of the evidence that takes a different take, that is supported by the evidence that the state produced to us. And we have an obligation to make sure that our client gets a fair trial.
Judge, if I may just add something. It appears from what Mr. Quinlan said that they're not trying to prevent us from speaking to the media. I think that's what I heard him say. We obviously have a First Amendment obligation, just like the media has a First Amendment right to report. We are not trying to waste time in this case. Our client has been in custody for almost 2 years. We want her to get to trial as soon as possible, but it makes it very difficult. This is not your normal case. With media attention, it unfortunately brings us having to respond to things. And one thing that I think is a perfect example of that, Mr. Quinlan mentioned that recently, within the last 48 hours, there's been news media coverage about the Clenneys being arrested. And one of the things talked about tampering with evidence. And he himself just now said on the record, which I'm very happy for, about the fact that this is not a tampering case. There's no evidence of it. But you know what's going on in the media is that Mr. Prieto and I are being vilified as being said that we are instigating this and we had our clients alter the computer. That's what's out there. Imagine now we have to try to defend ourselves from what's going on. So we can't control what the media says, but as he said, we have to be able to respond. And so, you know, we had a motion to compel, which I know we just filed it last night based upon what's going on in the new thing. You probably don't, and they haven't had a chance to respond. We're going to ask you to try to put it on as soon as possible next week because our whole text communications were reviewed, and it is our whole defense laid out in the text communications, which were subject to this new charge. That's how the whole case started with this new offense. It's based upon reading work product that we had. And so now I don't know who has read the text from there. We're going to ask the court to do a protective order because God forbid that discovery comes out and now they can Chapter 119 request all of our text messages. But there's a lot of issues to deal with. As you can see, it's not your normal case. So we are just making sure we
calendar it looked like the good old
only
90s,
to make sure that we're not being prevented from being able to vigorously defend our client. It appears that Mr. Quinlan is saying he's not preventing it, so I think there may be no issues.
She's not Canadian.
Can I address one of the concerns the court had? Well,
I know where I was going anyway, but go ahead.
yeah, so the docuseries, I can tell the court, yes, we were approached and interviews were had. We were approached because somebody wanted to put a neutral message out there to get both sides. Not just let's call it the crazy elevator video side. They contacted us to put out a neutral documentary about.
How many of you thinks that TMC will make a neutral documentary about this one? Or would it be OnlyFans killer in a bloodlust, unquenched by millions of dollars, turns her boyfriend simp into mincemeat? Yeah, totally. They would not use clickbait to try and get people to watch it.
What the family perceives is going on here, and the evidence that the state.
The elevator video is kind of tame. She just hits him 5-6 times. It's the one from Aspen where she yells and screams at him.
Already put out in public. There's nothing there that the state didn't already put out through their complete.
Choose your words carefully.
Yes, Judge. They put everything on the table, and it was a buffet.
You saw that guy in the in the
And that buffet
JD.
is still, it's
They
stacked
just want
with food,
blood.
a never-ending supply of food. Another video produced by the civil attorneys, who, by the way, were on Court TV this morning, talking about defense counsel, talking about the video they released, I think, a week and a half ago. So, Judge, in my response, I cited the rules of professional responsibility. The model rule talks about this type of thing, that I am entitled to push back against the narrative that has been put out there. And I'm not saying the state is the ones telling the media, hey, have this narrative, but they're getting information piecemeal, as Ms. Puglisi says, these little snippets in time, and they are going to characterize them, demonize them, not the state, the media, as however they see fit. That creates the clicks on the websites, that creates more media attention. I believe the rules allow our, number one, the freedom of speech is obviously something that's implicated here, but more so to make sure my client gets the fair and impartial jury and trial. So
Let me do this.
sure.
I want to take it back to what the standard is. So I don't know that either of you are asking anything particular of the court, maybe a protective order. It sounds like you have already asked for a protective order, maybe you're asking for one now. The standard here, again, is whether or not any extrajudicial statements are substantially likely to materially prejudice the trial, which I think I hear from both parties. We want to have a fair trial. Obviously, that's the goal of all of this, is to have a fair trial. And how do we do that in the presence of such media scrutiny? Are you both suggesting, or are neither of you suggesting, that we should somehow tailor this so that both sides are prevented from giving more media, attention or discovery? I just want to hear what it is that you guys are suggesting to me, because I hear from you that you were worried about this from the beginning, and that you're worried about the media's response to the discovery that's been put out there. I hear you guys saying that you are worried about what defense is saying in the media about their case, about the victim in the case, and potentially whatever this docuseries is or will be. So what are you both suggesting or requesting from the court? I'm going to hear from the state president, Dr. Puglisi.
Yes, Judge. So regarding the respondent and the defendant's motion for protective order, the state actually believes the court should tailor. I think it's the juncture where the court needs to tailor some kind of order over the parties. To the protective order that the defendant filed, the issue with that order, and the court well knows, the state's role is to function as administrative justice, and we could not go along with that as much as we'd love to. Limit our office, because it's drained our resources. Our PIOs contact us to direct them to our evidence and discuss what's in our evidence. And that takes away from our time litigating this case and other cases, as well as investigations. As much as we might love to do that, we cannot lawfully stand in this court and be like, yeah, Judge, seal all the discovery. We cannot. And that was our position then. It's our position now, and it will be our position always. And even if we had gone along with the defense's position, might not would have appealed it, they would have won, and we'd be back at square.
I understand that wasn't what they were asking, but
They were asking the court to in-camera micromanage discovery. That was their injunction. And that discovery was subject to public practice. So it was the court superseding Chapter 119, which was the state's issue. There are collateral issues, nonetheless. Handling the case in Florida, as opposed to federal court, has for a litany of cases presented its challenges, because we are the Sunshine State, and Sunshine is the best this is happening. And so the state of Florida, and as a prosecutor in the state of Florida, we believe in Florida State and their right to scrutinize us, scrutinize the defense, scrutinize laws enforcement, and scrutinize our case. We welcome that, and that's perfectly okay. The problem becomes, counsel gets a call. What do you have to say about this new video that was released by the attorneys for the family? No comment is easier than going on TV. Or, my client is innocent, we'll prove it at trial, no comment. Or the evidence will show my client is innocent. It does not necessitate outing a victim of sexual battery on television. It does not necessitate that. And certainly it's available in discovery, and certainly it's subject to public records. And just like the respondent leaked to a local news station regarding body camera from 48 hours before Christian's murder, and then gave an exclusive interview, frankly, that's subject to that too. We can't do anything about that. And the TMZ special, that bell is wrong. We can't do anything about that. The court does not have authority. And again, this is as a minister of justice and a prosecutor. The court cannot preclude TMZ from airing whatever footage they had. And that's where counsel's inappropriate actions require attention from this court. And that's why it's a petition to show cause in this form from the state, because his professional judgment.
Christian is the victim of sexual battery. That's what they are saying. As they stated before, the defense have tried to smear him. the video he talked about that was body cam video for 2 days before the incident is where she's standing in the foyer of that penthouse or that apartment thingy they lived in, and crying and say, "I want him out of the house. I want him out of the house. He's so bad to me." So he's correct in that the defense is just as much as the state putting stuff out there. All the videos where she's crying, where she claims that he beat her all the time, are put out there by the defense, and all the videos where she hits him, of course, is absolutely not put out there by the state to prejudice anyone. They would never do that. But the sexual battery is that they believe that Christian was a victim of that. Hey, MMC, welcome. Oh, and by the way, the estate of Christian, the family of Christian, is suing the apartment complex they stayed at because security knew what was going on, according to them, and didn't intervene to stop the violence.
Your Honor, I've been an attorney for 7 years. I went straight to violent crimes, and I've been doing this for quite a long time. But counsel has been an attorney for over 20. And he will
I think it's another way to try and turn it around to garner some.
As a matter of fact, the victim's family included TMZ interviews and specials. The victim's family was also approached, and they turned down interviews and interaction with TMZ.
So what is it that you're requesting at this point?
Your Honor, I subject all the parties to no public statements unless it's procedural. And the state would gladly about it. And I can't speak for counsel for the civil case. I don't know the court's jurisdiction. I don't know if the respondent represents the defendant in the civil case, but a similar remedy could be sought in the civil case.
That's the problem though, judges, is you can't preclude the civil lawyers, you can't preclude the media from speaking. You know, the train has left the station and it's now too late for us to prevent that. I mean, I'm not really going to get into much about the outing the victim as a, sexual victim. It was taken out of context. We've explained it. There was no intent to try to shame anybody here. But we can't simply say no comment. We're taking our client to trial. We think she's innocent, because that's just not good enough. It doesn't stop the media from continuing. Every single day this is on TV, on court TV, they're constantly reporting on it. And so we have to be able to speak up at this point and respond. Now, I understand that those comments need to be ethically made and done professionally, but we can't be prevented, or we should not be prevented from making comments at this time, because it's not just, and I'm not saying the state makes comments, because they don't, it doesn't come from them. It comes from others. And unfortunately, I don't think the court can stop that happening. And until the court does have that jurisdiction to stop the media from actually speaking, then I don't think we have any remedy.
Judge, if I may make one comment. But the issue here is we're also still before a lot of different evidentiary motions. There's going to be a lot of things that may be allowed in, that may not. The problem is when comments are being made about things that will not be coming into the trial, there may be jurors who are listening to these interviews. They're going to hear this and then look and inspect it. And that's the problem.
Yeah, this is the issue that I have, again, about the issue of materially prejudicing. They're being material prejudice to us getting a fair trial. Some things I think, no, it's not an issue. A lot of the stuff, things that the argument hearing, those things, those have
someone is moving the mic
around. The
around.
issue becomes when you're having a docuseries where you are allegedly putting forward, purported evidence and witness statements prior to us getting to any of these evidentiary hearings or getting to trial. I think that you come a lot closer to the standard. And I think that you do come a lot closer to potentially prejudicing a fair trial. And that's what I want to prevent. That is my jurisdiction, is to make sure that I am doing what I can to make sure that Ms. Clenney has a fair trial, to make sure that the state has a fair trial, and to make sure that it hasn't completely been tried in the court of public opinion before we get here with a lot of evidence out there that's not going to be necessarily evidence.
Kind of like the Murdoch trial.
So that is
remember, that was a Netflix show before the trial started, or just around the time the trial started. Because I talked to my sister in Switzerland. She's not really that much into true crime. And she knew about the Murdoch trial. I said, how do you know about that? Well, I watched the show on Netflix. How many people were tainted by that show? Was that a fair trial?
But what happens with the discovery that is already in the possession of the media through Chapter 119 that won't necessarily be admissible in trial? Because we all know there's a lot of evidence that doesn't actually get admitted, but they are already showing those things in the media. And so those people you're talking about are seeing those things.
I think that those are, I mean, listen, I'm not saying that you're wrong about it being unfortunate that, fortunate or unfortunate, the reality is that we are a sunshine law state, and that we do have a very wide, there's very wide latitude given to what people can request with regard to the discovery in this case. What I can prevent on that or not, I don't know that I can. I think that that's something separate. But again, you know, I agree with you that all of that's been taken by the media, and that everybody knows, you know, everybody across the world, I think, if they're interested, knows, you know, what potential discovery is in this case. But the question is there anything that needs to happen now, given the fact that we do have that wide latitude with our sunshine laws, to try to make sure that we are doing as much as we can to make sure that we are going to have a fair trial. And whether or not comments on either side, or whether further interviews, which aren't subject to a sunshine law, the interviews don't have anything to do with sunshine law. They don't have anything to do with the ability of the public to get the evidence in the case, to get the discovery. That's not sunshine law. That is something that I would consider sunshine.
That's First Amendment, though, Judge.
Some of
That's
it
what
is,
it is.
but I mean, but all the case law has to do with, you know, how the First Amendment abuts narrowly tailoring any sort of restrictions on the First Amendment. You absolutely do have, you know, First Amendment rights, and I think that there has been a lot of case law that has struck down restrictions on that First Amendment right. But there's also been case law that has upheld that when it is very narrowly tailored and it's done correctly to preserve the fairness of your defendant's right to a fair trial and the state's right to a fair trial. So that's what I want to hear from you, is why it is that you believe that you should be able to, you know, do this docuseries, that you should be able to make all these comments, and why you believe that that is not going to materially prejudice the trial in this case.
Judge, again, the state let the toothpaste out of the tube. It cannot be stuffed back in by Your Honor, by myself, or the state now, perhaps in hindsight, could have had a filter team going through discovery, and yes, it would have been more work for everyone, but that would have prevented it. But that's water under the bridge. At this stage, I'm asking the court to take no action on this petition, deny it outright, because we have to, when more discovery comes out, we have to have the ability to push back. So for example, Court TV calls us almost twice a week, and we don't go on very often. When we do go on, it's because they had a panel of experts analyzing video and commenting about what these quote unquote experts think the video shows. And that is improper for us to remain silent about. For example, the elevator video. Nobody talks about how that elevator video, the elevator goes directly into the client's apartment. Nobody talks about this gentleman having the only fob. And if we are not able to push back at the level that we've been pushing back against the media mischaracterizing the state's discovery, that will materially prejudice our client. And I haven't heard any, as Judge, we presented at our motion to get some type of limit on or filter process for the discovery in this case. We had empirical data of the number of hits that the elevator video got. We had our IT expert conduct searches, and we gave the court empirical data of how many people were looking at this. The Miami Herald came back and said, oh, we only got 2,000 clicks, when there were millions. You know, too bad for the Herald, but there were millions nationwide. The state has not presented to this court any empirical data about who's even watching these interviews on Court TV. So at this stage, I'm asking the court to deny it, not impose any type of restrictions upon the defense. We think that what we've put out there is a counter narrative to mischaracterization of the state's discovery, that we're not materially prejudicing anyone, any potential conviction. There's no substantial likelihood of that. The substantial likelihood already occurred when the state just dropped every piece of evidence out there, whether admissible or not, for the consuming media, the media to consume it and digest it and then spin it however they want. We have to push back, and I think the case law supports the court taking no action this time.
And we're doing it consistently with the First Amendment.
Judge, may I respond?
Yes, we will.
Counsel's last words were, we are obligated to put out a counter narrative. The premise of that statement is, I want to try this in court publicly. To put out a counter narrative, there must be an original narrative. And to put out a counter narrative against the state, which is done in a trial, in court, the state has not put out any narrative. The state just produces evidence. We do not release statements. We speak in court. A person obtaining any sort of evidence, such as autopsy photos, and mischaracterizing that autopsy photo, is their right as a citizen in Florida, period. We cannot control how people misperceive things. We cannot control how people misdirect things. Neither can counsel to this.
as Sue said, yeah, both sides are, well, we want to spin the narrative when we feel like spinning the narrative. And now the state is standing there saying, no, we didn't, we don't talk about the case. We only talk in court. But I'm pretty sure that someone told, I'll tell you a little secret from back when I was in politics. We have a local newspaper. You'll soon in politics get to know which journalist you have to talk to if you might have a good story that you would like to see in the papers. So let's just say that you have a good story you want on the front page the next day, maybe to hurt another party or to say how good your party is. You call that guy because you know he always listens, because sometimes you maybe give him a good story and sometimes you give him a bad story. Don't tell me the state doesn't have at least 5 different journalists. They know. If we tell you go look at exhibit 2125, that'll be great. It's absolutely not a video of her hitting him in an elevator. They'll look it up the next day. Of course they do. And of course the defense does the same. But now let's play all holy and we don't want the media to influence the jury. Of course you do. As long as it's for your side, you'll have it in there. This being in Florida, just tough cookies for both sides. Florida has the most robust sunshine laws in the country. This judge can't do much. No, and she said so far, but again, it's just a hypocrisy. Oh, we didn't do anything. We're just answering to the narrative the state put out. Oh, we don't put out a narrative. We just show the evidence. We have a sunshine law. No, you make sure the right journalist looks at the right place to find the right video. Don't tell me you don't do that. That's BS.
And we can see that. But again, no one from the state is trying to try this in the court of public opinion.
Of
And the
course they
defendant
are.
is trying more specifically to respond, is trying to see the panel before
And-
it gets here.
And I don't know, half the people at Court TV are former prosecutors. Does anyone in this courtroom maybe know someone over there who takes off the record phone calls or trips to the golf course? It's politics. It's PR. Of course they do it.
That's the particular problem. People without credibility on the internet making wild accusations, wild statements on both sides, because it's not only against the respondent and defendant, have no basis being validated by any of the litigants, and particularly counsel. And that's why the court should impose, at this point, the only thing that's going to limit the prejudice for the immediate problems, because I understand from the most recent TMZ posting is that this special is airing a week from next Monday, is time, which is a delay. And if the court recalls the last setting, the state said, we're concerned about getting dumped a bunch of witnesses and then a speedy demand. That's just not saying in this case, I'm saying that's a constant concern for litigants across the board. And that's a problem, is that the only remedy at this juncture, particularly with an impending docuseries, is time. So if the defendant and the respondent chose to file a speedy demand so that they can try this case in the wake of this directed, at least based off of the emails that we received, the courts received, a perspective-based docuseries, they could do that. And the state is left without remedy. And that's the particular problem. The court needs to resolve it now so that with time, the roiling boil.
Yeah, because again, they know the journalist
That's their problem.
called to say, oh, this.
And they can err and
this
say whatever they
video
want. That's their
that
problem.
tonight.
But the litigants have no basis in saying anything to the media, period. The litigants should only speak in court. And that's what the state has done, and that's what the court asks to impose, consistent with the Toledo.
Judge, I would just say that the First Amendment has a very high standard, and the state has not shown any evidence to support that speaking to the media will affect the jury pool. Your Honor even said, if this docuseries, we don't know. And unless there's data or evidence to support it, it cannot surpass the First Amendment right.
And Judge, we are, it's on the record. Ms. Pugliese and I said it last in the court. We are not filing, if the state's concern is we're trying to try this in the wake of it, we are not filing a speedy demand. It's on the record. I stand by that. Ms. Pugliese stands by it, and we stand by our reputations in defending our client.
Judge, I have one last comment, and it actually goes to a further request from the state. So as counsel had mentioned, the fact that they had to put their narrative on, say, the elevator video. What the attorneys say, and we all know this, what the attorneys say in trial is not evidence. that specific narrative would have to come from his client if she so chooses to testify in a trial. The reality is this is where we run into problems with these interviews for this TMZ program. Now, obviously, Your Honor may not have jurisdiction over TMZ, but Your Honor does have jurisdiction over the parties here. My understanding is you have to give permission to publish anybody's statements in any of these documentaries, and I believe Your Honor could put in an order to ask and order the defense to not authorize TMZ to post their statements in that, that documentary. And I think that is the appropriate remedy here.
The court could order the parties to revoke their release,
Correct.
their press release, their release for their, particularly within the legal.
Okay, we want to take all this into consideration. When did you say that you thought that this was?
According to the TMZ snippet from yesterday, it was a week from Monday, this coming Monday. So whether that's still the case or as heard, Judge, I can find what I saw yesterday and send it to the court and counsel.
So I'm gonna have an order for all this, like you said.
Judge, can we talk about, I'm sorry, that was another matter. So can
Okay, so
we,
this, I'm gonna have an order on for Tuesday. If you want to give me a proposed order on the motion to compel the evidence as we discussed today, that would be great. I would recommend an order on this. Yes.
can we please next week schedule a hearing on the defendant's motion to compel and request for evidentiary hearing? It was filed yesterday, so I know you don't have a copy. We can forward you a copy to Chambers, so you'll have it. But it obviously deals with a lot of sensitive information. One of the things I'd like to at least know right now is, are Mr. Prieto and I, do we have our phones being recorded, our conversations recorded?
So, we'll give you a copy of yours. State, did you say that you have already filed another motion to compel, or?
No, Judge.
In response to their motion?
Yes, so the court, I raised today that Mr. Clenney is listed witness by the defense. The state is entitled, just like the defense would be, to memorialize statements by a witness in the case. They have no obligation to list a witness. So if he had not been listed, they would have an obligation to provide a statement. But they are in possession of statements by him.
Can you get anything that you think that you are entitled to in a motion by tomorrow?
Judge, I will additionally say, though, I don't think we can hear that motion until after, because he is, yeah, because he has a charge now. He's going to have a lawyer, and
Yeah, so, and that's what I was gonna say, Judge, and I think that matter is also, the collateral is related to the defendant's motion to compel last night. So, I think what would be wise, just to evaluate some drafting time and how long it would take to respond. We could respond to their motion to compel and include within our response what we are compelling from the defense regarding Mr. Clenney, if the court follows me, I'm sorry.
And Judge, I want to caution the state, or if you can caution the state, part of what we're seeking is disclosure by the state of what we consider to be either attorney-client or work product communications.
Or that you're seeking?
Yes, because the state is in possession of our private communications. If the state is going to be filing any kinds of responses attaching these communications, again, they're letting the toothpaste out of the tube, it needs to be filed under seal.
Just don't attach it.
Because we've also made a lot of these communications available to defense. If it's over a terabyte of information, we will have to work with defense and communicate to get a device from them to be able to put all of these on. That being said, we're going to tell our public record people to not release without further order from you regarding the.
For those information, yes.
Correct.
Yes, Judge, so that's gonna be part of litigation, is whether voluntary disclosures to third parties are privileged.
Yeah, unring the bell,
or work product.
genie back in the
Again,
bottle,
voluntary.
We'll wait for your order.
Okay, so.
BS
Tuesday,
back
I'm
in the
going to
cow.
respond to this. If you could, I'm gonna look for a copy of your motion. If you could reply by Tuesday.
Yeah, it's because her parents, all of
Next Tuesday is the coming Tuesday.
Yeah, I mean, my concern is that you seem to have some urgency here about obviously the non-disclosure of what you consider privileged.
Right, Judge, because we don't know how the filter team was. Are we going to need to move to recuse the entire state attorney's office for not following proper protocol, for searching into communications that are privileged? There's a lot of issues here, but I really want to know, because Mr. Prieto and I were named as principals in their warrant. Are we being recorded, our conversations? Can they at least answer that today?
Okay, so that's the urgency of what.
Judge, there are no wiretaps. These were pursuant to 2 warrants that we provided counsel and are part of the public record.
And can we also make it clear, since the media is listening, that this is not a tampering case? There's no allegation, at this time at least, there's no allegation that anything was done to this computer to tamper with it.
We only recovered the laptop on Tuesday that should have never been in the defendant's possession.
That's not
true.
All right, so we will, here's what we're gonna do. It sounds like you need more time to
Yes.
respond to that. They have given me their assurances that you're not being recorded right now, which takes away that urgency.
Or any warrants being served on our iCloud accounts or any of our personal communication devices.
There have been no warrants served on anything regarding Mr. Creates or Ms. Lucy. The warrants have been served regarding Ms. Clenney's iCloud, Ms. Deborah Clenney's iCloud, Mr. Clenney's iCloud that was kind of commingled with Ms. Clenney's iCloud. That was served in November. We don't have any of those matters pending. There will be upcoming warrants on both of Mr. and Mrs. Clenney's iPhones. There is an upcoming warrant on Mr. Ogunselli's laptop as well.
But not the council.
Not, we have not sought any warrants for process on council.
The problem is there are work product, attorney-client communications
On their-
on their phones with a group chat.
So that's, again, voluntary disclosure to third
Because
parties.
we're not litigating that issue now. You can receive, the state can respond and
Here's what
we'll
we're gonna
argue
do.
with.
For that, I'm gonna give you 2 weeks to respond to that. If there's some sort of emergency that comes up, or you believe that there's an emergency where you believe that something is going to be disclosed that, you believe is privileged, I'm gonna bring it to my attention. I'm gonna put it on the state to do the same. If you know that something is going to potentially, be an issue, you gotta bring it to my attention. But right now, I'm gonna give you 2 weeks to respond to that. That doesn't take away the fact that I'm gonna, have this order for you on Tuesday.
And lastly, Judge, related to that is, we'll be doing a motion to quash a subpoena. It was filed against our defense expert, and it's set for, or his interview with Ms. Hogue is set for the 9th, which is next week. So we'll be in the
Can you do that on
process.
Tuesday as well?
Yes, Judge, we'll have that filed. I just wanted, because I know we may not hear it, but until that gets done, we would move to, hold off on any kind of interview. He is being represented by Jude Facidomo. So, but we believe, because it's our defense expert, that it's us who would be doing the motion to quash. So,
Just get it filed before the 9th and,
Yeah.
No, the 9th is the.
It's the date
It's
supposed
the
to
day
go.
for the-
For the subpoena.
He's supposed to go.
Okay. So if that happens, obviously you need to hold off on anything if there's a pending motion to quash.
Yes, sir.
All right, anything else for today?
Regarding that motion to quash, I will probably need 24 hours to reply.
I don't think she's necessarily requiring a reply to it, she's just saying that.
He's not going to show up for the
yeah,
9th.
she's
Yeah, that's just housekeeping. So, the last two questions. Mommy and Daddy may have used that guy's laptop. No, it's more that Daddy took it away from the crime scene, and they might have tried to access it by way of Courtney giving them the password or them trying to break into it. I haven't seen the affidavit against the or the warrant against the parents, but it's something like they might have tried to get into it. How and what they are supposed to have done on it, I don't know. Why the shenanigans if they had such an open and shut case? You work for a lawyer. Have you ever met a State Department not making shenanigans? If she feels any guilt that her parents were arrested. Have you seen the hotel video from Hawaii where she went and met with a new guy and stayed with a new sugar daddy? She didn't seem to have much regret. I don't know what you would call her, a narcissistic princess or something like that. That's to me what she seems like. But yeah, you have. I think she doesn't feel any remorse. But again, always innocent until proven guilty. That's a trademark for Broker Baker Incorporated. And for those of you who wanted to see the bad pictures, warning, warning, warning. We're going to see some pictures. It's not that bad, but don't have your kids in front of the computer right now. You saw the way she acted in Aspen, and the way she acted when he allegedly say hi to her girlfriend. She flipped her script totally. Yeah, maybe a little of the red stuff. Okay, kids at daycare. Well, I learned last Saturday. I should warn people. I don't think she feel anything. I'm sad to say, but she looks better now than she did at the last court hearing. So maybe if she is not that banged up on coke, she can do better. But this is from back when it was released. This is the crime scene photos of where you can see in her covered in blood. And yeah, it's this is her on the night in question. I would point your attention to this part. This is not hair dye. Only one fingernail. And these are white pants. Just so you get an idea of how she looked on the night of the murder. Accident, alleged murder. And her feet. Here we have her hands with all the nails torn off. Only one nail left. These are her NBA pants. They used to be white. I'm betting this will get demonetized. I just wanted to read. Oh, it's so. Where is the part where they describe what happened or allegedly happened? That's down here somewhere. Yeah, and there's the note where he writes, "You're the sweetest and most annoying woman I know." Yep. And he recounts the time he read her a poem and described her as his personal sunset. Isn't that ironic? Well, I'll find that because allegedly, according to the state, she stabulated him in the chest. But can I find? I believe it is in this one where she claims that. Look how happy they were. This is the. But I would never trade you for anything. We will go back to loving each other like in the beginning, and I will not hesitate to drag you to the aisle. I want to be everything to you, your boyfriend, your best friend, your lifelong partner, the man you trust to put his life on the line for you. I swear, Courtney, you are worth more than anything. I could never lose. I could ever lose for love, for your sake. What? I do believe that dreams come true, and I would love for to help me fulfill mine, which may be yours also. And notice it's torn up. And this is more pictures of her hair. Oh, look at that red rose. Doesn't it seem like it's not supposed to be red? Her feet. She should really do something about those nails. They're not nice. A Miami court recently heard in details how Clenney made her money and that she earned $966,692 in 2020 and $1.8 million in 2021. I'm skipping this YouTube business and going to OnlyFans. She funneled 1.1 million and 50,000 through wire transfers into his father's bank account after killing Publicity. Prosecutor claims she was stashing away money that would have enabled her to flee the country. This is their nice apartment. I don't understand why people like this live like that. Use some money to have someone to clean your house. Your trash on the floor, it's nasty. And Clenney's lawyers has claimed she stabbed Obumseli in self-defense after he grabbed her by the throat, and that a day earlier she was visibly shaken and fearful as she accused him of stalking and beating her. They are arguing that photos released last week of bruises on her body make the case for her to be on house arrest, but prosecutors say bruises were seen on her body in Instagram posts before the day of the killing. Don't be on Instagram, kids. Prosecutors say she's a flight risk because she can do OnlyFans all over the world. So, yeah, this is her in trial earlier. She has quite a dump truck on her. Prosecutor says the suspicious timing appeared she was attempting and otherwise preparing to frustrate justice and avoid criminal prosecution. Defense attorney said she spent her money on buying a house in Texas and creating ties to the community there. We don't think she's going to flee. Yes, she wasn't released on bond. This is her on the night. Let me paint a little picture. That's blood. That's blood. That's a nipple. That's blood. That's blood. That's blood. But she was just defending herself. Poor doggo. Come on, let's get so slow. To bolster her self-defense story, Clenney's attorneys previously asked that Obumseli's corpse be dug up and inspected by a medical examiner. Said Clenney claimed to have stabbed Obumseli in the chest after he grabbed her. But Clenney said she threw the knife at her boyfriend from more than 10 feet away. But Fernandez said an autopsy revealed a deep wound that could only be inflicted from a close distance. So her claim was she threw the knife from 10 feet away. I don't know how much 10 feet are in meter, but that's why I said I love they have a knife throwing expert coming in to testify in this case. I actually think. Let me just pull this down because I think one of them has. Come on, stop it. What the F? I think actually the knife is here too. And let me tell you, it's not a throwing knife. Oh, no, it's not here. But do you know those global knives? They were famous some years back. The one with the weird handle. It's one of those. One with a serrated blade. Absolutely not a throwing knife. But she hurled it 10 feet. 10 feet and pierced his chest. Around 3 meters. So yeah, she's probably not there. I don't think that she could throw it that far. I'm sad to say, especially penetrating because again, the chest cavity is actually protected by bones to make sure we don't die easy, because that's all our important stuff is up here. So yeah, I saw you sent me the stabbing device. I'm just looking it up. My web searches is gonna be so bad. Yeah, and over to the other screen. If you're squeamish, look away, because this isn't the nicest. Clearly a throwing knife. It was clearly a throwing knife that she used. Yeah, I don't think the jury is going to buy that either. It's such a stupid excuse to what they claim happened, that she threw it. No, and that's why I know she's probably said it because she thought, if we watch, I covered the Vegas interview with her as well. Her biggest problem wasn't that she was going to prison, it was if she could vape, because she needed her vape. Her vape was very important to her. And she had just beaten up her Christian that night as well. Her priorities is just effed up. So she probably thought, I'm so smart, I can talk myself out of this, because she had done that her entire life. She's just pulled out the meat bags, fun bags, and guy said, okay, that's okay. And that's not going to work in court, sadly. Well, there's probably some horny jurors as well, but she comes off as a big narcissist. I'm sorry to say it, and of course she's not guilty until proven guilty. But the way she acts in front of police is really, really stupid. I don't know. Yeah, I don't know, but I just thought we should cover a little Courtney Clenney, so we had something to talk about and get ready for the weekend. And then tomorrow, it's the guy's fault for liking her fun bags. It's always our fault. We should absolutely, as a agenda, figure out to not put our D's in crazy. But the problem is we do that all the time because we're not that smart. And sometimes the little head thinks more than the big head. And that's when ladies like Courtney gets us. But yeah, I think her problem is she's always getting her way. And she could get away with everything because she was probably a hot girl for her high school. I don't know where in Texas she was, but she got the blonde hair, and she used to be an IBBF, or trying to be an IBBF pro, International Bodybuilding Federation. And she tried to do that. I think about half a year ago, I found some of her workout videos. Let's just say she knew already back then what's the important part of working out. It's the booty and it's the chest area. It hasn't that much to do. I think she was training back or something, but I saw more of her titlets than I saw of her back. And the part of the back I saw was the lower back. So yeah, she's spoiled, and she thinks that I can charm my way out of this. But the problem is she doesn't look like she did with all the filters on. And she's 27 now. She's not a 16-year-old in a small town in Texas. So that's why she probably said that stupid stuff about, I threw the knife over 3 meters. That's just stupid. The amount of force you would have to generate and the accuracy, and they're gonna have a knife wielding expert. I won't be sad I'm not that knife wielding expert. But that was kind of what I had on planned for tonight, and now I'll go take Molly out for her night walk, and then we will cuddle on the sofa before we'll go to bed. And tomorrow, as always, at 9 o'clock, I will be having Stabio Day with hopefully Jamie, hopefully Mo, hopefully Sal, and the lovely Danielle. So hope I see you there for a couple of hours of a few crazy things. I don't know what we're going to talk about. It always go the wrong way. Isn't stabulating a person/rage crime? Well, it should be, right? There's only one there. Yeah, she was mad as hell. She was so jealous it was almost psychotic. But the way you said hi to one of my friends, yeah, he was on the phone with you while he did it. Thank you so much. Thank you so much. On the couch. Yeah, I'm gonna watch Love on the Spectrum just to let me know there is a chance I can find someone too. And then me and Molly is going to talk about how sad my life is. On that note, I'm going to send you over to Dave again. The defense has just started their closing arguments. Thank you so much for hanging out. And hopefully you'll be back 9 a.m. tomorrow where we're gonna have a show. I don't know what it's about, but it's gonna be fun for a couple of hours. And Glenn will take us out of here.
Your Honor, I apologize.
What exhibit are you referring to?
I'm going to make this 100, Your Honor.
All right.
100, because it is 100% correct.
Objection, Your Honor.
Do you see the lawyer's face? Okay, we have to go back and they.
Widower case.
Did you, whether it's true or not, believe that Mr. Randolph had slept with your wife?
I wouldn't care.
You wouldn't have cared?
No,
Did you believe he had slept with your wife?
no,
Did you believe he slept with your mother-in-law?
probably did. Everybody has.
Wait a minute, I need this story time.
Everybody has.